Good morning, everybody. My name is Seann McAleese, and my presentation today for you guys is employee privacy and addiction in the healthcare sector. Pleased to have you with me. We're going to go through the presentation, and then I'll have a question and answer period at the end. But certainly you can send the questions through as they pop into your head, or some issue that you think might be relevant. And then, as I said, I can review the log at the end and respond to all of those questions. And I can see that on the chat box as we go forward. So thank you very much. We're going to start into the presentation. So in terms of the agenda, you'll see we're going to talk today about employee safety and privacy rights. And in that question we have, what about the patient? You'll see in some of the case law review, my view is that seems to get lost. But we will certainly consider the extent to which employee health and safety impacts your ability to manage the hospital, and we'll use employee name tag as the example to cover. The second area, which is frankly of increasing importance, addiction and impairment defense, and I sort of call it, and you'll see it referenced in the case law, as a get out of jail free card, which is how it's been treated by arbitrators, I think, historically, although that's changing, and we'll cover that as well. But ultimately, we want to cover generally what you would need to know as hospital administrators and operators in order to manage employees effectively that raise addiction issues, both as a defense but also as a request for accommodation, and obviously our Human Rights Code duty to assist. Now we'll deal with, first, as I said, employee safety and privacy rights, and that relates to the Freedom of Information and Protection of Privacy Act. You also have to balance that with the Occupational Health and Safety Act, Regulated Health Professions Act, college regulation, and an example there is the College of Nurses of Ontario, whom, as you know, set standards of practice for nurses and registered practical nurses. And we have to look at the case law. What do arbitrators say about employee rights around safety and privacy, and how that relates to patients? So a lot of these are difficult, conflicting requirements for hospitals as employers and hospitals as care providers. Now, the first case that I'm going to review that relates to this is the Prairie North case. And it's the first one that dealt with this issue. It arose in Saskatchewan, and it related to the employer's introduction of a new name tag policy where they added the employee's last name. And they already had a photo, job title, and first name previously. The arbitrator in that particular case struck down the policy on 3 grounds. They said that the requirement to include the last name was a violation of the employee's rights under privacy legislation. They felt that it increased the employee's risk at the workplace, so therefore a violation of health and safety provisions. And thirdly, they felt that it was an unreasonable exercise of management's rights under the collective agreement. So on all 3 counts, the arbitrator in this particular case struck down the employer's attempts to impose a name tag requirement. So in that context, Cambridge Memorial Hospital had their implementation challenged by all of the unions at the hospital challenged, but the first one to proceed to arbitration was OPSU. And this is currently the first and only case in Ontario, and it does, as you'll see, trade heavily on the case out of Saskatchewan. And this case was released earlier this year, I think about March of 2018. And specifically, it addressed the issue of whether the hospital could unilaterally require employees to have their full name on the employee identification badges, so first name and last name. Now, as you see, there's a bit of a spoiler alert, and maybe this is my own rose-colored glasses. The arbitrator did rule against the employer in this case, but it wasn't a definitive no, you can't do this. It was more of a not yet. There's a step that needs to be undertaken prior to implementing this. And we can, we can deal with that as we go through the case. And you'll see what things we learned from in this particular case in terms of what we need to address next time should a hospital be challenged on its implementation of a name tag policy. So this particular case arose in the context of Cambridge Memorial having a significant grant. They were expanding the hospital grounds, upgrading facilities, including security, and they turned their mind to the issue of employee identification and obviously how that relates to security and issuing new passes. For issuing new passes, let's have a look at how we're administering those passes. And they sort of reviewed the practice at the hospital as it then existed. And they noticed that it varied by bargaining unit. Different departments had different rules. Different managers within departments had different rules. Some employees had the full name on their tag, but they obscured it with a button or some other, like a sticker or something on their tag. Some would, I know the slide says turn around when they're seeing patients. I don't mean to suggest they turn their back on patients to hide. I just meant they turn the card around in order to hide their name. So it was a real mixed bag, and there was a policy in place that said full names were required, but it wasn't consistently enforced. And in this context, the employer decided, well, this would be an opportune time to harmonize our name tag practice and enhance professionalization amongst the employee population. So as part of its, sorry, I missed the slide here. As part of its review, the hospital conducted an environmental scan and dealt with the prevailing practices at other hospitals to see what was going on. They also looked at the evolving focus on patient experience and how important that was, and asserted that, and the arbitrator agreed, that ultimately the full identity of the provider, the care provider, bore a strong relationship to the patient experience. It was important to trust. It was important to integrity and accountability, and even collegiality, so that employees interacting with one another at in the hospital could identify one another and obviously have some sense of skill sets and identification. And the arbitrator and the hospital also noted that for many it's a college requirement to self-identify, and so there shouldn't be something terribly new about imposing this requirement across the hospital. Probably one of the best quotes that occurred in this particular case from one of the witnesses for the hospital was, and you'll see it on the slide here, which I thought sort of aptly characterized or aptly summarized from the patient's perspective why a full name might be relevant. And she said, if someone is asking me to disrobe to be probed or prodded, I'd like to at least to know their first name, if not, buy me dinner. It wasn't enough to sway the arbitrator at the end of the day, but it was certainly something that you could relate to as a patient. The other part about the context that was well established again in the case, which you'll see why that's important, and it's set out if you ever want to pull up the case. You'll see the president and chief executive officer of the hospital actually wrote a letter to the staff prior to, or as part of the announcement, but prior to implementation, and set the context this way, saying patients and their families seek our care when they're at their most vulnerable. They come to us not by choice, for the most part, but out of necessity. In doing so, patients exchange their privacy and in many cases their dignity so that we can inject them with medicines, question their habits, open them up, draw blood and bandage them. Some are anxious, most are in pain. They entrust us to care for them. And the letter goes on for a few more paragraphs, but it was sort of an excellent job by the hospital to establish the context within which it felt that this was an appropriate measure to implement. Now, Arbitrator Marcotte, faced with that background evidence that I've just sort of quickly reviewed with you, applied sort of the long-standing KIP analysis, which is really a balancing act that arbitrators will go through in assessing whether or not an order or a rule implemented by the employer is reasonable. So he certainly found that the identification policy had a reasonable objective, sort of accepted the evidence of the hospital around why it was important, including the rationale articulated by the witnesses and the CEO, and also importantly found that there was nothing in the collective agreement that prohibited this, and there was nothing in the collective agreement that rendered this policy inconsistent with something in the collective agreement. And I think both of those two principles, part of the test, should apply to equally to many healthcare settings. Certainly the rationale would apply, and typically, there aren't any restrictions in the collective agreement that relate to employee name identification. So those issues certainly shouldn't be a problem for hospitals implementing this if they're challenged in future. The issue is around the balancing of interests part of the test and assessing the health and safety component related to that. And unfortunately, the arbitrator accepted the really speculative evidence of the union, even though no actual harm was demonstrated. The examples they gave are about, somebody was given the finger, somebody else was asked out by name by a patient, and somebody else said, hey, I know where you work, while they were at the hospital, so that probably wasn't, that wasn't a lot of detective work required for that. And there was no nexus between these activities or these incidents and the name tag and how it was relevant and led to a greater risk, such as the employee being stalked outside of work, the employee being communicated with by name outside of work, or in any way that name being deployed in a way to intimidate or harass a particular employee. In any event, the arbitrator felt that that the harm was a potential issue, and I should also note as well that everybody agreed ultimately that the employer could require, and indeed the college requires in many cases for regulated health professions, that the full name must be provided to patients. So if a patient wants to know who provided care to them, they're entitled to the full name. They can request that of the person, they can request that of their manager. So there was no mystery associated with that, and they would certainly be entitled to that information in any event. So ultimately, really at best, all having the name tag would do, I suppose, would be to sort of expedite the person who was seeking to harm an employee in some way, shape, or form. It certainly wouldn't prevent them from exercising any of that nefarious behavior, because they're entitled to that information anyway. The hospital, in this particular case, did consult a variety of stakeholders prior to implementation. They discussed the policy at labor management meetings. They also had an excellent workplace harassment policy. And in that harassment policy, they provided for exemptions for employees upon request. So if an employee had a particular concern, they could provide that rationale to the employer, and they would exempt them and just require a first name or a last name or an initial. There might be exceptions in the mental health area. One can appreciate that maybe readily identifying employees may not be appropriate in all circumstances, or may go through a vetting process, so at least management knows that somebody is requesting that particular employee's name, and precautions could be undertaken at that point, though that already existed. The issue for the arbitrator ultimately is he was troubled by the fact that the hospital had not undertaken a formal risk assessment under the Occupational Health and Safety Act, as is required in order to assess this if it was a new risk. And concluded, the arbitrator in this particular case concluded, again based on speculative evidence, that in fact this would be some sort of a new risk. Notwithstanding the fact that, as I indicated earlier, the policy existed previously, it just wasn't uniformly adopted, and had been continued for several years without any incident of harm that the unions could point to. So ultimately, the arbitrator found, because there was a potential new risk and the hospital had not conducted a risk assessment, whatever that might look like, this rendered the rule unreasonable, because it was potentially a breach of OSHA, and the balancing of interests in this particular case, given the safety concern and the procedural flaw on the part of the hospital, resulted in the favor falling on the employee side of the ledger. So ultimately, that was the basis for the policy being struck down. And I should note as well that the union had advanced the same arguments that were advanced in the prior Saskatchewan case, but the arbitrator only accepted this narrow basis to object to the policy, did not agree that there was any breach of privacy under FIPA, finding that at the end of the day, your name is certainly connected to how you perform your duties, and obviously, part of the circle of care, part of that, necessity for patient transparency and accountability and service, made sense that they should be entitled to the full name. So there's certainly no breach on that count. I would note, and it was sort of a bit surprising, the other cases referred to in the decision, you'll see arguably sort of a far more dangerous circumstance, one being the Toronto Police Association several years earlier had challenged the Police Services Board attempt to implement mandatory full names on badges in the police context. And as you no doubt appreciate, that's a context which involves organized crime, people that police interact with that are generally on adverse encounters. I mean, police don't generally stop you to say hello and hope you're having a nice day. So typically the encounters, have an element of aggression or concern or something that might upset a person. And if they had ready identification, maybe that would expedite their willingness to cause harm if they were so inclined. But ultimately, the vice chair concluded that that the association hadn't met its burden, and that is to show that somehow knowing the name would increase the risk of stalking or threatening behavior. And same as the hospital context, people people were entitled to request the officer's name from the officer. They were entitled to request that from the station. So the information was available. The real issue was, what is having it on the person's body? How does that expedite a potential harm? And that's really the only risk they could potentially point to. And as I said, the vice chair at the board rejected that. Ultimately, Marcotte addressed that case without comparing contexts so much or circumstances, but by saying that, well, in that forum at the labor board, the onus is on the union to prove a risk. Here, I'm sitting as an arbitrator and I'm just balancing interests and, whether or not this is appropriate generally, and who does it favor. I'm not going to require the union to prove any kind of material risk. So again, it sort of fell down on the procedural failure to conduct the risk assessment. So what do we take away from this particular case? Ultimately, as with many areas that we deal with as employer counsel, we all know, and you probably all know from your own experiences, any ambiguity or uncertainty is generally going to be resolved in the employee's favor. Even though this is a hospital context, even though we're talking about a vulnerable patient population, it's something that ultimately, we've got to make sure that all of our ducks are in a row, both procedurally and substantively. Also, if you're going to implement this policy, or as I said, many hospitals and healthcare providers have this policy, the real issue is it's not consistently enforced and people kind of deal with it on their own in terms of obscuring their names or other things. So if it's implementing a new policy or if it's requiring a full compliance going forward, we're going to have to conduct some form of a risk assessment so that we can demonstrate to an arbitrator that a process has been followed. And that would satisfy the concern that arbitrator Marcotte had in our particular case. Because as I indicated before, there is no doubt that it's a reasonable thing for a healthcare facility to require, that is full identification of the employee to the patient. And that's not going to be a problem to establish. So it really is making sure we get this procedural component correct. Now, I'm going to go from the employee's sort of health, safety, and privacy, and we're going to deal with addiction and impairment issues. Now, as you will all know, obviously there's an opioid crisis, and I think all are agreed on that. Add to that, we've got the legalization of cannabis, and it's a difficult context for employers, and we'll deal with testing and the limited ability of employers to do testing in a moment as well. But it's a very difficult area for employers to navigate. Now, on the employer side, you certainly do have the presumption that, and the expectation, and indeed the statutory requirement, that all employees report to work fit for duty, that they maintain that status throughout the day, and obviously especially in the healthcare sector, where I would say to you that the vast majority of positions are safety sensitive in the sense that how they conduct their role will have an impact on patient outcomes and patient health and safety. So, and in that context, I would note that on the date of legalization, the College of Nurses of Ontario took that opportunity to remind its members that under the Regulated Health Professions Act, working while impaired is considered professional misconduct. Again, nothing new, but obviously they sort of felt it prudent to take that reminder. And based on some of the things I've encountered to date, it certainly probably was prudent to remind people, because a lot of folks took the legalization of cannabis as a license to perhaps engage in use they might not otherwise engage in. The important part, I think, of this of the college reminding its members is that last bullet, and that is nurses are also responsible to report to their employer if they believe another nurse or healthcare provider is impaired. And it's important for a couple of reasons. First and foremost, it's certainly important because in many of the cases I've dealt with that deal with these addiction issues, employees that are terminated as a result of utilizing narcotics on the job or stealing narcotics while at work, is many of their colleagues have observed, if not actual theft, they've certainly observed behavior that was suspicious, wastage that wasn't done properly, might observe concerns around whether or not the patient was getting the proper dosage. So if there's concerns of that nature, they have a duty to report that to their employer. And frankly, if employees aren't doing that, then that is a basis upon which to counsel and or discipline employees, because obviously that's, it's part of the responsibility, and it's part of the hospitals or healthcare providers' mandate to provide safe and effective care, to make sure that all employees are doing so in a completely cognitive way without being under the influence of drugs or alcohol. So I think that reminder is an important one. And it's also, frankly, an important one for employers to remind their own employee population of, whether by policy or just simply by reminder through a meeting or other email communication. So the case I want to cover that deals most directly with the issue of addiction and the defense to termination as a result of behavior that employees allege is related to their addiction or their impairment is the Cambridge Memorial Hospital and Ontario Nurses Association case from 2017. And in that particular case, the RN was terminated for cause. She was caught stealing Percocets and Tylenol 3s, and whether from wastage, diverting it from patients, in which case, which she admitted to, and which ultimately meant that the medical administration record for the patient was false because they weren't getting the dosage, which obviously raised concerns about whether or not a subsequent nurse would come along and say that perhaps the dosage needed to be up to some extent because the patient wasn't responding. So it raised a number of concerns, obviously, in terms of how the employee is acquiring their narcotic. In this case, the grievor had 28 years of service and a perfect record, and in fact was being considered for a promotion to management within a couple of weeks of actually having been caught. And in this particular case, the addiction claim only arose, not surprisingly, as it often does. I'm a bit cynical, but it arose once she was caught, and once the allegations were made that her conduct obviously amounted to difficult behavior that needed to be responded to through discipline as opposed to counseling. And ONA in this particular case relied on the history of awards that exist, and there's probably about 7 or 8 prior to this case, in which arbitrators had uniformly treated the addiction and impairment issue where nurses had stolen narcotics from the workplace as a disability issue, and required that employers pursue it through a non-disciplinary means. So accommodation, restrictions around whether or not they could be around narcotics or administer narcotics, whether they would have to engage or be assigned to a different area, which would lessen the impact. All of those types of things that you might normally think of around accommodating somebody's particular restrictions. And frankly, it was to the point where ONA counsel expressed to me at the outset of this case that he was surprised we were even attempting to defend the discharge on the basis of cause, given the significant amount of case law that had evolved to that point. Now, fortunately, the employer in this particular case wasn't frightened off by ONA counsel's assessment of the case law and the unlikely success. And indeed, arbitrator Randall upheld the discharge of the nurse and ultimately found that, the mere fact that an employee says, I have an addiction, isn't in and of itself a defense to a termination. They have to, the nexus alone isn't evidence of discrimination. And, and the cases had gotten to that point where literally all an employee had to do was just simply say, I have an addiction, that's why I was stealing, and they would get a get out of jail free card, as I referred to it in that particular case. And that's where we were at, which had sort of gone a long way from what the Human Rights Code protections were intended for, and essentially perverted their application, frankly, because ultimately in these cases, and indeed many of the prior ones, the termination that and they were all hospital cases, the termination wasn't due to the fact that the employee was addicted. The employer wasn't saying, I don't want to employ addicts, or I don't want to employ people with disability. I'm terminating this person because they stole narcotics or endangered patient safety, and absent the addiction, that would have been the same consequence. So how can that amount to discrimination if you're not terminating them for any reason related to the disability? As I said, it's simply due to the fact that a theft occurred. And the arbitrator in this case was persuaded by some of the other cases that had arisen in British Columbia and Alberta. One was, for example, a liquor store case in which an alcoholic employee was stealing from their employer. That was obviously their source for their product. And in that particular case, there's no dispute. They were an alcoholic. That was accepted. But the court, or the arbitrator, and ultimately the court agreed that the termination was due to the fact that the person was stealing from their employer. The fact that they had a disability was irrelevant to the employer's determination. And you only, in the proper application of human rights, of the Human Rights Code, you don't get to the accommodation analysis until and if the employee or the union proves that the employee was discriminated against. If there's no discrimination, there's no requirement to accommodate. But that sort of bifurcated analysis had gotten blurred by the previous cases. And just to add one further piece to that, which is helpful, the Ontario Court of Appeal itself has said in even more stark terms, if the employer didn't know that the employee had a disability, even though there might be a nexus, then that doesn't equal discrimination. That in fact, the employer can't be said to have discriminated because they had no idea that the employee was suffering a disability. If they didn't know, then there was also no duty to accommodate that particular employee, and therefore no breach of the Human Rights Code in the event the employee was terminated. And that case was a cause case where an employee was terminated as a result of aggressive behavior, intimidation of other employees. And in fact, they had a recognized disability that caused that type of behavior. And the court nonetheless said it's not discrimination because the employer had no idea about that until post-termination. Now, I should say, and as you folks are probably aware, I mean, the employer can't obviously turn a blind eye to potential accommodation requirements. So if all signs pointed to the fact that the employer had some idea, such as this employee had told their supervisor or had talked about it with other employees who then shared it with management, then that would be potentially a different outcome. And the same would apply in these addiction and theft cases at the hospital level. The other point I would make, and you'll see that's on the last bullet story on the slide, and I'm going to deal with why this is important in a few slides later as well, but the arbitrator observed in really a prescient way, because this issue came up subsequently in a Supreme Court of Canada case, that the outcome probably would have been different if this employee had come forward voluntarily and disclosed their addiction before they got caught stealing. That would be better optics, but it would also relate more to a Human Rights Code issue and engage that type of accommodation analysis as opposed to a disciplinary analysis. The other rather helpful thing, frankly, that arbitrator Randall added in the case, which I think is important for all healthcare employers, is the importance of general deterrence. And that is, in assessing whether to vary the penalty, the importance of the deterrence effect has to be taken into account. And in the healthcare sector specifically, he notes, I would be remiss to not mention my concern with respect to general deterrence. It is trite to note that workplace discipline has both specific and general deterrence purposes. At a time when opioid addiction is rampant in the culture and a major issue for healthcare professionals, sending the message that pleading addiction only after being caught stealing one's drug of choice should be strongly deterred, which again dovetails with that the prior observation on the other slide, and which again is helpful generally to employers. Now, and that should obviously be part of the any disability and accommodation plan, especially related to addiction policy that you might have in the workplace. So, what lessons do we learn as healthcare employers from the Cambridge Memorial case? Well, absolutely, we need to make sure that our policies articulate the requirement to disclose the need for help, the fact that you have an addiction in order to avoid the disciplinary consequences, that has to come first. And if you fail to disclose, then that's going to have consequences that will be treated and dealt with through a different mode, namely discipline. So that needs to be clear. Also need to, on the other side of it, in terms of the stick and the carrot approach, we also need to make sure that the policy provides for robust statements and protocols that demonstrate the employer is willing to accommodate and it will assist employees that come forward with addiction claims, and that they can do so with some confidence that indeed the employer will go that route. So not only the policy needs to say that, but there needs to be examples of where the employer has done that in the workplace. And in particular, for Cambridge Memorial Hospital, they certainly had evidence that they had done that when the employee came forward. So it wasn't sort of an empty statement in their policies. It was something that they actually implemented. Now, the other factor to consider, and this comes sort of some of the Oberter statements, or the statements that the arbitrator made that don't necessarily govern the judgment, but I think would be helpful in future cases. And that is, you have to take a look at, how bad was the impairment? And there are cases, and one of the earlier cases, it was actually a return offense where the employee was terminated. RN was stealing narcotics. She was terminated. The arbitrator reinstated her on a last chance, essentially, and that she was subsequently terminated in future because she continued to steal from the employer hospital. And the arbitrator in that case found that the severity of the impairment was so serious and severe that she had no appreciation for her actions, and really it was a compulsion. And that influenced the arbitrator to again reinstate that particular nurse. And it was to the point where, again, the nurse was shooting up in the nurse's waiting area. Some of the employees had observed that behavior, again, hadn't reported it, all of which obviously created concerns for the arbitrator and resulted in reinstatement in that particular case. Again, this predates the Cambridge Memorial Hospital case, but I think even with the Cambridge Memorial Hospital case, facts of that nature would likely result in a reinstatement if the employer terminated for cause. Now, you may still be able to rely on the failure to report and come forward for assistance, but again, that would depend on how far down the addiction tunnel this particular employee had gone. Now, in assessing the level of addiction and compulsion, you may even think about whether you consult a medical expert in addiction to get an opinion on the circumstances. May consult legal counsel, obviously, and have a consideration of how this looks from the reported case law, and to sort of discuss the strategy and how it's going to be implemented, and sort of generally review the overall circumstances that apply to the particular employee. Finally, I would encourage employers to definitely consider reporting any of these narcotic thefts to the local police. Obviously, it provides evidence that the employer views this as serious misconduct because it in fact reported the thefts, and indeed there's a statutory requirement to report such thefts, and obviously it has significant criminal code implications for employees, which may ultimately affect what they do on the civil side or on the arbitration side. I don't generally think you can go wrong with reporting, and indeed, and I would suggest to you that there's probably a requirement to make sure that those things are reported, because if there were subsequent issues with patients not getting appropriate dosage or litigation arising out of that, the fact that we didn't think it was serious enough to report to the police may cause concern for us in defending that type of litigation. Now, on that point I made about the importance of disclosure obligations, obviously, from two perspectives. One, it's obviously important to ensure that employees have access to treatment, to EAP, that the employer, demonstrates that it's quite willing and able to accommodate employees, as is its duty under the Human Rights Code, obviously to the point of undue hardship. There's that, but then there's also the second element that's important is that can be in and of itself a separate basis to terminate the employment relationship for cause, irrespective of whether or not the employee in fact has a disability, or even if the incident in question relates to the disability. So it's important for two reasons to make sure that policy includes an articulated statement around disclosure, and that it's enforced and tracked and dealt with. And this arises not only out of sort of inferentially out of the Cambridge Memorial Hospital case that we just covered, but it also arises out of the more recent Stewart versus Elk Valley Coal Corporation decision out of the Supreme Court of Canada. And as I said, this came after the Cambridge Memorial case, but sort of continues on the same vein. And that is the employee here, I believe it was operated a forklift, had an accident at the work site. It was related to, or the allegation was related to cocaine use. And, the allegation was that termination of the employment amounted to discrimination, just as we've seen in the prior hospital cases cases prior to Cambridge Memorial. And, and that was a discriminatory act, and it was as a result of his addiction to cocaine. The Human Rights Tribunal, in that case, interestingly, found that no, the termination was due to the breach of policy, not because of the addiction. And again, that relates to my earlier comments to you about, the termination relates to theft of the alcohol from the liquor store, it relates to theft of narcotics from the hospital or from patients. That's the reason for the termination, not because of the addiction. And that sort of that bifurcated analysis, was followed by the tribunal and then followed by the Supreme Court of Canada as well. It upheld the tribunal's decision and found that ultimately there was no evidence that the addiction that Mr. Stewart suffered had any impact on his ability to comply with the policy, that is, disclose usage and seek appropriate treatment. And that's what the termination letter was clearly relying on and articulating as the basis for the discharge, that is breaching the policy. And that had no connection, obviously, to Human Rights Code disability requiring accommodation. You didn't need to be accommodated in order to comply with the policy and report the fact that you were using narcotics. So that was a very helpful one for employers as well, especially read in conjunction with the Cambridge Memorial Hospital case. Now, another area I wanted to briefly touch on relates to testing for drugs, which is something that's drugs and alcohol, I should say, which is something employers have long attempted, and it's gone through the various courts, both in Ontario and Alberta and elsewhere, sort of up the chain to the Supreme Court of Canada. And basically, the efforts, to sum it up, by employers have been rebuked by the courts generally, that it's not appropriate to engage in random drug and alcohol testing, even in safety-sensitive positions, in and of itself. There has to be something more in order to do that. And more recently, you're probably all familiar with this from the news. I think it was heavily reported that the Toronto Transit Commission case, a court case, and I should note that there's an underlying arbitration that will deal with the merits of whether or not the drug and alcohol testing can be sustained, and the arbitrator will have the final say on that. This part of the case really arose because the union went to court trying to get an injunction against the TTC to prevent it from implementing the drug testing until the arbitrator decided. And in that context, it was really an assessment of whether it was appropriate to implement the injunction, and was there irreparable harm? Who did the balance of convenience favor in terms of whether the status quo is preserved and testing continues, or whether it's halted pending a decision on the merits? And in that case, the TTC led quite a bit of evidence about the sort of culture of drug and alcohol use that existed, and obviously its concerns for commuter safety and the fact that, obviously all of these vehicles are operated on public motorways and thoroughfares, and, that there was a significant interest in public safety, and that was what this was, this testing was geared to. And obviously, I think the healthcare sector, healthcare employers could make the very same argument about the safety-sensitive nature of the role that these employees perform, and that, patients may be at risk depending on how the employee conducts their job. Now, ultimately, and you'll see the quote below, the law still remains, as sort of summarized below, that random testing might be possible where, A, it's a safety-sensitive workplace, and 2, there's evidence of a general problem with drug and alcohol abuse. Now, the extent of that evidence will obviously vary depending on which arbitrator you're in front of, if that's where the fight is, or if you're at the Human Rights Tribunal, if it's a non-union employee challenging random alcohol and drug testing. So it's, I think that it gave a bit of hope. There was a bit of light. The window opened a little bit for employers with that TTC case. And the Suncor Energy case was actually on appeal, referred back to the arbitrator, saying they didn't get it right. And that arbitrator had struck down Suncor's efforts to impose drug and alcohol testing. So there may yet be a positive decision out of Alberta that deals with random alcohol and drug testing. And as I say, there is an underlying arbitration on the TTC case, although there's no indication as to when that decision might see the light of day. So it's certainly an area where employers can continue to think about whether or not they have a need to implement this sort of measure in their workplace to control substance abuse and to contribute to patient safety. Another interesting angle that's also worthy of consideration by employers generally, and which helps on the accommodation analysis as well. And that is the very recent case, Lower Churchill Transmission Construction Employers Association. And the arbitrator in that particular case had found that the employer reached the point of undue hardship because it wouldn't hire an employee who had applied for a safety-sensitive position while they were being prescribed medical marijuana. And in that particular case, the arbitrator found that the use of medical marijuana, no surprise, can cause impairment, which can last up to 24 hours of use. Residual impairment can impact functions the day after the evening of usage. And this next one's quite important, and the fact is, and many of you may have received notes from a general physician if you've asked for confirmation that an employee who's using medical marijuana requires some form of accommodation in that they need to be allowed to smoke it or ingest it somehow at the workplace. And this arbitrator found, and frankly, I think the College of Physicians and Surgeons would admit as much, that GPs aren't really well situated to comment on what the impairing impact might be of marijuana. And now this applies, obviously, post-legalization, whether it's medical marijuana or whether it is simply recreational marijuana. And there is an actual statement by the College of Physicians and Surgeons of Ontario on the issue of impairment through marijuana, in which they essentially say there's no way that we can accurately determine a level of impairment. We'll start with a low dose, and we'll start with a low dose and low THC, and we'll move up from there depending upon whether or not the patient reacts favorably to the treatment. But there's no ability to say to an employer that they're not cognitively impaired or they're not physically unsafe, or that they may injure themselves or somebody else. And finally, we get to the last piece, which is frustrating for obviously on the police side of things, but also for employers as well, that there's no readily available testing that can demonstrate impairment. People have different responses to THC, so the quantity alone may not indicate the level of impairment. There's difficulties with measuring the quantity of THC, and there's no specific mechanism on the horizon that will allow for testing. So what was unique about this case is many employers have been faced with the problem of employees objecting to testing, but B, in this particular case, as it relates to marijuana, them or their unions saying, well, what's the point of testing? It's not going to show whether or not I'm impaired anyway. It's just going to show that, in the last day or 2 days or 3 days, I've consumed marijuana. So, you can't deny me this job, or you can't deny me this reassignment, or whatever it may be. You simply have to allow me to work. And that's been, frankly, the position of most unions. And you'll see, and you've probably seen from the news, that different employers have taken different approaches given the inability to test accurately, whether it's Air Canada or the police in Toronto, for example, which have said you can't have consumed it for certainly in excess of a month, or we're not going to be able to continue at work. We want you to be clean and free of anything until the testing comes up. And that's also occurred, as I said, in other transportation-related sectors. But that's going to be challenged, and I think in the Toronto Police context, their union has already submitted a challenge to the ability to require this sort of ban or prohibition from use, even though it's legal. So that's the context for employers living in. What this arbitrator did that was helpful was sort of flipped it on its head and said, no, I think maybe we have this all wrong. The employer obviously has a duty under Occupational Health and Safety Act legislation to make sure not only the particular employee is safe, but that other employees in the workplace who might be impacted by how this employee performs their role, if they're impaired, that they might be exposed to some other risk. And that's the employer's obligation, and they wear that statutorily and may indeed wear that civilly if there's an accident that injures members of the public or otherwise. So the arbitrator said in that context, maybe the proper way to approach this is that the employee, once they've disclosed that they use cannabis, whether recreational or marijuana, that they have to satisfy the employer that they're free from impairment. That they're the ones that have elected to use the substance, that they in fact should have the obligation to confirm that they're safe. So that obviously brings us back up to point number 4, which is there are no tests to confirm whether or not it's safe at this point in time. So using that analysis and that logic, the arbitrator, in my view, quite properly, said that it wasn't discriminatory for the employer to deny the employment, because it can't, in his words, can't manage the risk if it doesn't know how to measure the risk, if it can't possibly measure the risk. So all it's left with is the blunt tool of you can't use if you want this job, or which is sort of the approach, as I said, that the Toronto Police Service has taken. So in that sense, I think it's a quite helpful decision going forward. Now that brings us, we're sort of 45 minutes in. We do have 10 to 15 minutes for questions, if anyone wants to send questions in. And I do certainly have one right now, and that is, how would an employee establish that theft was a compulsion arising out of the addiction versus a controlled habit or a conscious choice? Excellent question. And ultimately, I mean, aside from expert evidence where you might have somebody in addictions testify to that, or if you had some testing results that might show you quantities, again, maybe not so much from marijuana, but from opioids, which have a bit more of a clear line to assess impairment. Absent those, then you have to look at the features of the case. And in the Cambridge Memorial Hospital case, as well as a couple others, but didn't carry the day, but in ours, I think it assisted, the employee was able to, on her own evidence, steal the narcotic or divert it from the patient, put it in her pocket, and only consume it when she left. So, and one never knows whether or not that's true, or whether that was the defense that was taken, because she thought, well, if I admit that I stole narcotics and used them on duty, then the arbitrator is going to be concerned about whether or not I tended to patients who were while I was unfit, and maybe she thought that was probably the bigger risk, or maybe indeed it was truthful and she didn't have a significant compulsion, in fact could just take the drug for future use. She also testified to the fact that she could go a week or two on vacation and not require their narcotic. That she could also go quite some time. She had a second job actually where she worked at a family health team up north, and she claims that at no point did she ever steal from that particular employer, notwithstanding the fact that she had access to narcotics. And again, taking it at face value, that helped us to demonstrate, I think, to the arbitrator that this isn't, a compulsion, that she has the ability to take the narcotic and then consume it later, which again shows you the ability to control your behavior, and that you're not, that you have moments of sobriety where you can appreciate that what I'm doing is wrong, because I'm able to defer it and use it later. The other evidence as well that would be relevant to that question is that she was able to perform her job quite admirably. And in fact, many of her colleagues said that she was excellent, had no performance concerns. Indeed, as I mentioned at the outset, she was being considered for promotion by the employer. And those were all things that I think sort of the arbitrator looking at that was that, well, she clearly wasn't the nurse who was visibly impaired shooting up in the nurses' lounge. This was somebody who did their job admirably. No other employees, detected any concerns or reported any concerns, and indeed she, was well respected by the employer to the extent that she was being considered for a promotion. So when you have those kind of facts, it doesn't look like an addiction to the level of something that's going to compel you to engage in theft or to put patient safety at risk. So if there's any other questions, you could certainly submit those. And if you have any questions in future, you'll see my contact information is on that final slide. By all means, you can shoot me an email or give me a call. I'm happy to talk about either of the two cases and the issues that relate to safety, privacy, and addiction. And hopefully can address any circumstances that you may be experiencing. Ultimately, we'd also appreciate if you find the time to complete the survey that's provided at the end. Just take a couple of minutes of your time. You can give us some feedback on future topics, what you might find useful going forward, and frankly, how useful you found this particular session. The next presentation that we do have scheduled is titled The Anatomy of a Contract. a risk management perspective, and that will take place on December 5th, and I believe an invitation for that will be sent out shortly. So thank you very much for attending, and again, I look forward to any questions you might have after the fact. Sorry, there is one. Sort of just read this quickly. We still have time. Have employees who are caught stealing or diverting drugs ever challenged the employer's drug control systems by suggesting that the employer should have had stronger controls in place to save the employee from themselves, potentially suggesting the employer didn't comply with OSHA? Good question, and in fact, no, there haven't been any in those several cases that predated the Cambridge one, including the Cambridge one. There was no claim that the employer didn't administer its system properly or that it left employees vulnerable, because in fact, one of the things we argued, because typically, and you guys will know from college restrictions being placed for a nurse that's caught, they will say, well, just restrict their access to Pyxis or whatever the drug administration system is that you utilize. That will keep them safe, and they won't have the ability to reoffend. And we would point out to the arbitrator that, well, unfortunately, there's many different ways the nurse can acquire narcotics separate and apart from the administration system, and that is, maybe a bag of Dilaudid that's being administered intravenously to a patient. There was one case where a nurse had taken used syringes from a sharps container. Some patients are admitted to the hospital with their own medication, and theoretically a nurse could take from their supply. So frankly, there are so many ways in which a nurse, if inclined, could acquire narcotics while at the hospital that I think it'd be pretty difficult for ONA to suggest, or unions to suggest, that the hospital needs to clamp down on its administration system. It would simply be, frankly, I think impossible. So that, as I said, an excellent question, but no, they haven't raised it, and I think for those reasons. So again, I appreciate it. Thanks for the opportunity, and I look forward to any questions in future. Take care.